Very nice to see everybody. As you perhaps know, I'm Andrea Squires, Head of Education at Winkler Sherwood. Supported the diocese MATs for a great many years. And this is the first of our HR updates for diocesan kind of contacts, MAT contacts, school contacts. But we're very keen to develop this and possibly even extend it to HR professionals in some of the other Catholic MATs that we work with. As you'll all appreciate, the world of employment law and HR is super complicated and sadly getting even more so with all the legislation that's coming our way, as well as change of regulations on the horizon. So we're very happy to provide an ongoing update. Both MATs, of course, are part of our school support service, so we do that through that route too. But I think it's quite nice to get together for now and again and just mull over some of these practical as well as legal issues. I'm delighted to be joined today by Ada Smilovich, who heads up our school's HR team, and Penny Reid, who heads up our school investigation team. And they will be providing the bulk of the content today. Again, if you're in need of any legal advice, in truth, you can just contact one of our help desks. We will advise on any legal matter, and actually quite a lot of the advice we provide is a bit more practical as well, looking at some of the policy developments. We will include today, of course, a very recent update with regard to settlement agreements and confidentiality provisions, which is all over Schools Week at the moment, quite rightly so. But I think the session is mostly focused on disciplinary practices and issues that might emerge, as well as processes to follow. I think both Penny and Ada will be happy to take questions. I guess if there's a burning question as you're going through, then do stop. I think it's always nicer to have a conversation during this session rather than I guess sit there quietly and be a bit frustrated. If there's something you really want to find out about, just stop us in our tracks, that's fine. But there'll also be an FAQ session at the end. And although I've got to drop out for a little part of this session, I will be there at the FAQ stage too. So actually, if there's anything broader that you want to ask about, not just pure HR employment law, then by all means save a question for the FAQ at the end. I shan't go on for too much longer. I shall hand over now to Ada, who will provide a bit more context for today's session. Thanks, Ada.
Thank you, Andrea. Yes, as Andrea said, we do want to make this as interactive as possible for you all. So as with last year's session, we had a lot of engagement throughout the session, sort of people putting their hands up, asking questions. So we very much encourage that. In terms of what to expect from today, we shared a fictional investigation report. It doesn't really matter if you've read it or not read it, because we're not going to deal with that until right at the end to encourage some meaningful discussion. But the agenda for today is just to go through the lifespan of a disciplinary matter, sort of from the point that allegations are initially triggered all the way through to an appeal, possible intervention by external agencies, when it might be appropriate to use a settlement agreement, and some common pitfalls. So we do have quite a bit to get through, and I'm going to pass to Penny to take us through the first half of the session. Thank you, Penny.
Okay, thank you everyone and welcome to this session. As I just said, hopefully it's going to be quite interactive, but it is going to be a whistle-stop tour through that sort of journey of disciplinary from the very first moment that we have a sort of trigger point, so to speak. And what we've said is that this trigger to potentially investigate or pursue any type of disciplinary allegations can arise in various ways. And we put some examples here for you. So you might receive an incident report. This might even come from a member of the public. It might come from another member of staff. It might just be something that's brought to your attention. It's Also, you could get a complaint. So that could be very much more specific. So you might get a member of staff making a low-level concern about another member of staff, or they may just come to you and complain about some treatment they have received. There's also regulatory involvement. So it's not uncommon. I wouldn't say it happens all the time, but certainly it could even be that you're, as a head teacher or a HR person, you may even pick the phone up to the police who tell you that they've arrested a member of your teaching staff. I've had that certainly before. So automatically that puts you on a slightly different footing in terms of how you approach it. But it can certainly come your way via that avenue. Again, there's also the possibility that the first you hear about an issue is via the LADO. So the LADO will make contact. They may tell you that something's been brought to their attention, for example, a member of staff's conduct outside of school even, how they've behaved within their personal life, and it's been brought to their attention, the LADO's attention. Also criminal proceedings, so being notified of and having a duty to report. And lastly, sometimes, again, I'd say this is more unusual because ordinarily you would hear from the LADO in the first instance, but you might get an invitation to a multi-agency meeting where a member of staff's potential conduct has been brought to the LADO's LADO first, and therefore you aren't on that front footing, so to speak. So it's not intended to be exhaustive, but these are the types of triggers that we see. So then you'll do your sort of preliminary steps. Some people call it preliminary investigation, but fundamentally it's just trying to establish that initial report of, is there some substance to the point where we need to do some fact finding? What's really important is that you address any immediate safeguarding concerns first. So if this is to do with possible conduct towards a child or a pupil in the school's care, then obviously you are going to need to follow your own sort of safeguarding protocols. Then you can decide which policy or procedure the report applies to. So again, do you need to be looking at your child protection, staff code of conduct? Is the concern that has been raised a whistleblowing allegation or disclosure? So take prompt but fair action, and check if you're obligated or prevented from investigating. So if we go back to the situation where the police are potentially involved, sometimes they can, well, more often than not, actually, they will say to the school, please halt any internal investigation because this potentially could be a criminal matter and we need to do our own investigations first. So consider whether you do need to do a preliminary investigation. Is that something that's written in your policy? We have seen it in some policies where it suggests that there has to be a preliminary investigation done prior to you deciding whether to do a formal investigation. Or on the face of what you've managed to establish, do you feel that you can address this with informal action? So, for example, if it is a low-level concern, and that doesn't mean that low-level concerns shouldn't be taken seriously, but if it's a low-level concern, you've spoken to the individual member of staff and you are satisfied that it can be addressed as a low-level concern, would you consider that informal action is the right course of action rather than embarking on a formal investigation? Take steps to safeguard any evidence. And what we mean by that is, for example, CCTV. This is often something, if you know that the incident potentially has happened in an area that's covered by a CCTV, please do consider downloading that CCTV and keeping it safe, because fundamentally most CCTV systems, I think, tend to keep the footage for around, I think it's between 21 and 28 days, but you will know that specifically to your school. And also consider a communication strategy. So this is far more around if, for example, it's a report that's come to you, potentially safeguarding concerns where the conduct is thought to be so serious that actually it could get out into the public arena, and you may get a local newspaper, and or it could be that a parent's noticed the conduct, made that parental concern to you, and therefore they may well speak to other parents, and before you know, the actual situation externally to the school has snowballed. So as much as you're dealing with things internally, you won't have huge amounts of control at that moment in time as to what's happening external to the school. And limit unnecessary involvement from people within the school. So by that we mean, I know it's really difficult to say that disciplinary action is likely, because at that point you're at the very early stages, but consider how widely you're going to share it for confidentiality reasons, but also you want to keep people very much out of the loop in case they're needed at different stages throughout the process. If it's a safeguarding concern that's been brought to your attention internally, in particular, you need to consider notifying the LADO as per your safeguarding protocols and your policy. You also may have to inform the DfE, the regional director, or the diocese. So again, that will be very much determined by the type of situation you are dealing with, but they are considerations that you will need to make. And finally, please do get advice and support. Either internally, don't forget that you have the LADO. We are on hand to offer you support in the first instance if you really don't know which path to take, but don't be afraid to reach out, because sometimes these situations appear to be relatively minor, but they can escalate quite quickly into something more serious.
Yeah. Just to add on to the which policy or procedure to use, we often have a situation where a parental complaint is raised, and that kind of straddles potentially the disciplinary or staff code of conduct policy, but also the complaints policy. And we've had cases in the past where clients have been really confused about whether they can rely on the one investigation the complaints investigation to support a subsequent disciplinary process. And our view generally is that you can, because it doesn't serve anyone interest to go through what is essentially a duplicate investigation covering the same evidence, speaking to the same people. So just, you might get employees or unions saying, well, you haven't done an investigation under the disciplinary policy. It doesn't actually matter. You've done a reasonable investigation and you've concluded that there is potentially a disciplinary case to answer. There may be issues around redactions, protecting confidential information or personal data belonging to parents and children. But ultimately, if it was a robust and reasonable investigation that complies with the ACAS code of practice, it doesn't matter if it was communicated as an investigation under the disciplinary process. We've got a question already. Go ahead.
Oh, I'm really sorry. Hi, it's Kate Warren here.
Hi, Kate.
It's just a question really with regards to unnecessary involvement. Can I just seek some clarification?
Yeah.
We've had some situations in the past where perhaps concerns have been raised that perhaps is something that needs to be reviewed under disciplinary. And very often I'm involved in that process. And then there obviously is an assessment as to whether or not disciplinary formal investigations need to occur, and the notification of disciplinary, etc., then happens. There was a situation not that long ago where it was advised that I wasn't allowed to be involved at all in the initial fact-finding process if I was then to lead the investigation process if the disciplinary policy had been invoked. Is that accurate, or what was your recommendation be, I guess, in terms of segregations?
I mean, generally, it's good practice to have different individuals doing, performing the separate functions where it's reasonable to do so, having regard to the size and capacity of the employer. But unless there is a conflict of some sort, or your decision making is tarnished, I don't necessarily think that just because you were the initial preliminary fact finder, you can't then subsequently be either the commissioning officer or the investigator. I guess we would need to understand what the other side's case is and why it's not appropriate to use you. And also, I'd imagine your policy doesn't say that whoever assessed it initially can't then subsequently be involved.
No, it doesn't. We use the CS policy, which I'm assuming the large majority or the vast majority on today would be doing the same.
Yeah, and sometimes unions will make very compelling arguments, very strongly worded arguments, but usually they're wrong. They'll talk about natural justice and this is outrageous and all these sorts of things, and it sounds really persuasive when you read it. But in those scenarios, do come, take advice from us. You've got the retainer and we'll take a view on it. But unless there's a compelling case as to why it's not appropriate for you to be involved, I don't see why you would step aside. Because then where does it end? The control then goes into their hands, and you almost lose control of the process. And ultimately, they'll have a right of appeal. So they can't predetermine that a process is tarnished before the process has run its proper course. Penny, do you have anything to add to that?
Not really. I think the only thing that I would say is it does tend to come up quite a bit from particularly union representatives, I think. But as Ada said, as long as there's a sound rationale as to why and you are following policy, then ultimately we can, for want of a better word, bat some of those kind of insinuations away. So, I would just say wherever possible, absolutely, so that we can bat them away at the outset. But sometimes it's just not possible. I would just say just have a very sound rationale.
Yeah.
No, that's great. Thank you. We've never had the problem before. It was just on one occasion. So that's great. Thank you.
Good. Also, just on that point, it strikes me sort of limiting unnecessary involvement. Sometimes the union or the employee, as a defence mechanism, will start writing very emotive letters and copying the entire trust board or the entire governing body in. And it's important to step in and say, actually, to protect the integrity of the process, you can't copy those people in because they may well be decision makers going forward, and then instruct your trustees or your governing body to simply disregard those communications, because that shouldn't be happening. It's tricky because staff and unions want it, both ways. They want a fair process with integrity and impartiality, but at the same time they're tarnishing people by copying them into correspondence unnecessarily. So as I said, it's important to just stay in line with policy, but keep control of the process, because ultimately you're the employer and it's for you to decide how you want to deal with a particular workplace issue.
Yeah, and I think also at that stage, you are fact-finding. So no decisions have been made, no outcomes have been decided. You are going through a fair and thorough process to ensure you're following your own processes, but also to keep both your staff and your students within the school safe. So I think ordinarily we tend to respond with, we are at fact-finding stage, and no decisions have been made as of this point.
Yeah, exactly.
Okay, so we've done all of this preliminary part of the process, and you have decided that you would like to do a full investigation. And so then you need to be thinking about, what are those allegations going to look like? So what allegations are we making against this individual? So we would suggest that you review the information you've collated to date. Again, think about which policies, standards, expectations the conduct has potentially breached. And allegations do need to be sufficiently detailed to provide the employee facing them with enough detail so that they feel that a fair process is going to be undertaken, but not so huge in terms of detail that it starts to make the investigating officer's job almost unreasonable. So, it's about being succinct, yet detailed, and being very fair in terms of the language you're using. So when you've written the allegations, have a look and see if the language could be open to different interpretation. Sometimes we have seen, again, as Ada just referred to in terms of the union reps' input, we can see how they find a way around them, regardless of the kind of substantive evidence that's been collated as part of the investigation. They can find a way around them if the allegations aren't drafted, considering what interpretation can be placed on the allegation. So one example I had as an investigating officer is that they talked about preventing, so the allegation was you prevented a member of staff from having their lunch when they have a medical condition. Actually, the individual hadn't prevented the person going to lunch, they just hadn't allowed them to go to lunch at the time they needed to go. They had diabetes. So the union rep had tried to say, well, that allegation isn't substantiated because the person had their lunch. So it's just that type of interpretation, just to be really thoughtful about actually what have we discovered so far? How do we want to put that into words in the form of an allegation? Are they fair? have we been clear enough with the allegations the individual is going to face? Always include dates of when the conduct allegedly took place. We're always talking at this point about them being allegations, so we can use the word allegedly or if proven, just so that we're being very clear that the allegations, what you're not doing in that letter that you send is saying this did happen. And as the investigation progresses, we often see that additional allegations can come to light. So our advice is that you must always write to the employee with those additional allegations. And if they've already been met with as part of the investigation, very much the investigation officer should be meeting with them again to discuss the subsequent new allegations. So we need to make sure at every point they've been given an opportunity to provide their perspective, their information on the allegations that they are facing. Is there any questions on that part of the process?
I suppose just making the allegations really clear helps any future panel, because I have supported panels that are just not entirely clear what they're being asked to decide or what the alleged misconduct is, because there is insufficient detail on the allegation. So, help your panels. Sometimes they're landed with a pack of documents that they need to read maybe a couple of days before, and we have had panels that have had follow-up questions not really being clear what case they're being asked to decide. So absolutely getting the allegations right is crucial. George?
It's more of an observation than a question. As a director, we get involved at the appeal level. And one of the things that we find very often is a lack of adherence to policies at an early stage. And so we get ourselves a little bit into trouble because we're not following what the procedure says. So things like writing things down. And the other observation is, and it's a question in this case, is should the investigating person be a person who's had any kind of training in questioning of people about things, open-ended questions as opposed to suggested answers, etc., etc.? And is this going to be part of your presentation today?
Shall I take the first one, Ada?
Yeah, why don't you?
The one about the investigating officer. So I think, again, it's what's reasonable, George. So if you're managing an internal investigative process, then yes, you could consider sending anyone that you may choose to rely on. I know that ACAS do some training. We actually provide more bespoke training in terms of investigation officers' roles. It's not a prerequisite.
Yeah.
I think I've only been asked once by a panel if I've had training, but certainly you want to support any internal investigation officer. It's difficult enough to investigate internally. So I would say it's not a requisite requirement. However, any tools that you can give an investigation officer to carry out the role really thoroughly are obviously going to benefit both the investigation officer and your panels if it goes to disciplinary hearing. The second part, I just have to remind me again, unless Ada's going to pick it up, the first part of your question.
About sticking to policies, making sure, it's more observation really, making sure that people stick to the policies right from the outset, that if there is an issue, look at the policy and then follow it.
Yeah, that's almost a learning point, isn't it? To just share across with colleagues that, the policy is there for a reason. And we always say to clients that the whole purpose of the policy is to ensure parity of treatment across the trust and across the school. And that helps you not get yourself in trouble. Now, minor procedural mistakes are not going to be fatal to a process. But as you say, George, unless, there's no good reason not to follow the policy. It's what it's there for. So it's more about habits and encouraging colleagues to use them rather than, any particular legal steer that we can give. Penny, on the training of the investigators, what I would say, having sort of developed the investigations practice with you over the last 12 months or so, is that the workplace disputes are just becoming really, really complex, and internal investigations are always subject to challenge, and the first line of challenge is always, particularly in grievances or whistleblowing investigations, is well, why would you find in my favour? You're employed by the employer I'm complaining about. So yes, training to people would be incredibly helpful, but even then we find that the investigation is subject to challenge because it's been carried out internally. Now, that's not to say you have to investigate externally all the time, and it would be incredibly expensive. And as I said earlier, it's for the employer to determine how best to approach the investigation. But it's definitely an issue, George, across the sector, that even people who are trained and skilled in investigations are being challenged as to their credibility and capability to carry out these investigations. And that's across, even parental complaints, I would say.
Yeah, I absolutely agree. I was going to pick up that point, Ada, actually, about external investigators. Again, as Ada said, it's not always possible in terms of finances, etc., but there will be occasions where the matter is either so serious or so complex, or the matter involves so many people who may be witnesses that actually it's nigh on impossible to conduct it, and nor would you want to conduct it internally. So I think that is a consideration that you need to give at that kind of preliminary, stage where you're collating the information, and then you can sit down and say, actually, is this best place to outsource to an external investigator?
Part of the problem is when at the outset it's not known how complicated it is, and so a head teacher might say, okay, we'll nominate X to do the investigation, and suddenly find it is far broader, and often these things are. But I guess you've got no choice in the matter.
Yeah, I think so. I think sometimes, George, if it's something, for example, like fraud, or it's some serious safeguarding allegations that originally has been with the police and then the LADO, and then it's been reverted back to school, or particularly a complex grievance or a grievance that's been raised against a senior leader, they're often the situations where we feel an external investigator could be best placed to investigate.
Yep, thank you.
Okay, so leading on from thinking about more serious matters, we will pick up on the topic of suspension, because as those around the call will probably be aware, suspension must really only be the last resort and should certainly not be a default action. So it does really need to be considered carefully. And also, as much as LADO do give really good and valid advice, just avoid the danger of simply acting on their advice. We would absolutely advise you, whenever you're thinking that suspension could be a necessary response, complete a suspension risk assessment and do genuinely give consideration to the alternatives. So action short of suspension, i.e., is it manageable for the organisation to offer some kind of supervision, or can you remove them from certain duties? So if we think about the Ford case, do you give them no access to financial systems? So that type of alternative could be considered. If you have completed a risk assessment, please do revise it as you go along and as the investigation progresses. So if you made a decision not to suspend in the first instance, but further information comes to light that causes you great concern, then revisit the risk assessment, and it may be that at that stage you may have to consider suspending. Must be temporary, so please do keep it under review. So again, revisit the risk assessment. Often on the letters it will say we will review the suspension in 3 weeks' time. If you have written that on the letter, please do go back to the employee in 3 weeks' time and let them know how the investigation is progressing and the suspension still stands. Please also don't use it as a disciplinary sanction. I know the word suspension, as soon as an individual hears that they've been suspended, as much as you can write it's a neutral act in the letter, they will hear it as a possible sanction or a possible precursor to whatever's going to happen further down the line. I can see there's a hand up. Is it Kate? Oh, she might not have heard.
Yeah, no, it's fine. I've forgotten my mouse. I'm rubbish at using my laptop. Sorry. Yeah, I'm really sorry. Just a quick one. So we have a risk assessment that we undertake when we're considering whether things are ladder referrals, low-level concerns, or potential disciplinary. And we have the same for suspension. But are there any kind of we've devised those, sadly, over time with experience in terms of cases. Is there any kind of format or suggested templates that are available to look at that we can perhaps just cross-reference with one we've already done?
Yeah, we've got a template suspension risk assessment and a suspension briefing note, which is essentially a summary of our advice on what you need to think about when you are considering suspension. So we're happy to share that after the session.
Oh, that'd be great. Thank you very much.
Just on the suspension point, we have had cases where action short of suspension has been imposed, but it's been made really clear in the letter that should the person not observe the modified duties or whatever that the action short of suspension is, they will be suspended. So it's important to include that pre-warning as well as saying, you know, should further allegations come to light or depending on what comes out of the investigation, just to give yourself as much wiggle room as possible should a suspension become necessary.
So suspension will ordinarily be justified if there is an ongoing safeguarding risk, again, down to the circumstances of the case. It can also be used if there's any sort of indication or concern and to prevent an employee from tampering with evidence or going through to other work colleagues to talk about the investigation itself, or if working relationships with other members of staff have broken down. It's not appropriate to communicate more widely about someone's suspension. So if you're in doubt, please do reach out and ask us for some advice in terms of the messaging. But fundamentally, you shouldn't be informing other members of staff that an individual is suspended.
We've got another hand up. Hello.
Hello. Hi. Can I just ask or get clarification on power to suspend in the sense of who that lies with? So is that with the head teacher? Because there was some discussion around that for a previous incident we had, that it had to be someone else, director or otherwise.
No, because I would expect it to be a head teacher at the school level. That I can't see why a director would need to suspend a teacher or a support staff. I would expect a director, if we're having to suspend senior members of the executive team, and I'm talking CEO, HR director, those sorts of roles, executive principal, because they are the only ones that sit above those roles. But no, I wouldn't expect a director to be involved in decision to suspend staff at local school level. And okay. I would be very surprised if your policies had that requirement.
Okay, that's something just for clarification, because that was fed back to me from a HR provider. So, okay, I'll...
Hopefully it wasn't us. Was it us?
No.
George has put a question in the chat. In the case of a suspension, can you say a few words about the school's rights the school rights of a suspended member of staff who is also a parent at the school? That's a tricky one, but we have lots of staff who are parents at the school, don't we? So I think the suspension obviously applies to their attending work, their working hours, coming on site as a member of staff, and so on. Obviously, if they need to pick up the child or attend a school event, we would need to reach some sort of arrangement with them where the risk of them coming into contact with potential witnesses or interfering with the investigation is managed. So I don't think we can prevent them performing their function as a parent, particularly if there's no other person who can pick the child up and drop the child off. But I think we'd need to put some parameters in place with regard to that. And we'd probably want input from our school support colleagues who deal with the parental side to sort of help you manage that.
Yeah. Okay, so moving on. So we're now sort of moving in through the investigation and the process and procedure. So as we've sort of touched on briefly, there are overlapping policies at times and multiple stages, but the fictional investigation report that we've shared with you is fundamentally around the disciplinary policy. But the purpose of the investigation is very much to gather evidence and establish the facts. So we always say, as much as possible, we want to establish facts, but if that's quite difficult to do, then the investigation officer can rely on the burden of probabilities which is a civil burden of proof. So is it more likely than not to have happened as has been alleged? See if there is a case to answer where the wrongdoing has been identified. But it is really important that the investigating officer looks for facts that support the allegations and facts that work against the allegations. So it very much can't be moving down that parochial vision of, right, this has happened, now I'm going to search for all the facts that prove this has happened. You absolutely have to be using those set of scales really and finding things from both sides. Make sure everyone is heard and treated fairly, because regardless of whether the recommendation is to move forward to disciplinary, what you really want as an investigating officer with your investigation is that you can attend that hearing knowing that you've carried out that investigation with the utmost of integrity, and that you have listened to people and you have considered their responses as part of your investigation. And the investigating officer's role really is to collate all of those facts, collate all of that evidence, produce the report. They are not the decision makers. They will be the people that say, this is my recommendation. I believe there is enough evidence to suggest that allegation 1 is substantiated, allegation 2 is not, and however many allegations you would expect them to say. And therefore, it's my recommendation that it moves to either disciplinary, formal disciplinary, there's no case to answer, or actually the matter can be dealt with informally. We always suggest referring back to the policy, because every school and trust has slightly different variations to the language used, but they are the 3 outcomes for the employee themselves. There will be some other operational recommendations potentially, i.e. I recommend that the employee undergoes some additional safeguarding training or is supervised when, there could be lots of different things, but ultimately the employee is interested in, is there a case to answer? Can it be dealt with informally, or am I going to be going to a formal disciplinary hearing? And always ensure that the appropriate guidance is followed. So we have, obviously, for an investigating officer, they have to look at ACAS. There is the statutory guidance. There is also the code of practice, and there's also some guidance. So we would suggest that both of those are referred to when carrying out an investigation. But if it's safeguarding, we have flagged up working together to safeguard children, and also keeping children safe in education, which is fundamentally our statutory guidance that we should always be referring to whenever we come across safeguarding matters. And one of the things that we need to do, and probably this should be the first bullet point actually, is once you know the formal investigation is a decision you are making, then determine the terms of reference. So what are we actually asking the investigating officer to do? What are the expectations of them in their role as an investigating officer? And you have to, and that really keeps them working to an actual path that they can't deviate from. And if they do wish to deviate, they have to have the conversation with the commissioning officer, and then you will go back and you'll revisit the terms of reference. And that would be the case if there were additional allegations that come to light. So then the next step is, as an investigating officer, they can create their plan. So that would come from the terms of reference. I always call this the kind of first review. So they might look at the paperwork that's already been collated, that preliminary stage. They may look at any of the statements that have been given to them at that stage. And they should be thinking about, who do I want to interview? Are there going to potentially be any reluctant witnesses? If there are, how are we going to address if they request to be kept anonymous? What is the evidence that I'm looking for? Has anything been referenced? So, for example, if the behaviour policy has been referenced, the investigating officer would say to the school, please can you provide me with the behaviour policy? Or if, for example, in relation to a child with special educational needs, is there a pastoral support plan for that child? So they're the kind of evidence pieces that they should be looking at as part of their first review. And as they progress through, they may well request to see more and more information. In terms of transparency, it's always vitally important that whenever they are interviewing witnesses, they are very clear with the witnesses that the notes that are taken during that meeting can be shared with a panel if matters progress. They will be shared certainly with the commissioning officer, but they may well be shared with the employee. Now, there is a risk once you are transparent that some people may hold back with their testimony. but actually we have a duty to be transparent about how that information is going to be used. And the entitlement to be accompanied, normally we see in all school and trust policies that they do allow individuals to be accompanied at the investigation stage. It's not a stipulation of ACAS, but it's very much considered to be best practice. So it is something that we always encourage our clients to allow. And certainly, even with witnesses, as much as they may not need to be accompanied because they are a witness, we certainly endeavour to allow them the opportunity to be, because the actual process can be quite emotional for anyone that's involved. Witnesses that are having to answer questions about their colleagues can sometimes find that very, very difficult. And I think in the fictional case that we've shared with you, we have actually deliberately chosen the kind of case that can very much split people's opinions. And that can be really, really difficult for witnesses to actually say, but I did smell alcohol on my colleague's breath. You know, that we can't underestimate their input into that process. Sharing on a need-to-know basis, again, that kind of links back to our point about keeping people sort of away from the process whilst it's ongoing, so they can't face any accusations of being biased if it does go to a disciplinary process. But also, whomever we speak to as part of an investigation, we absolutely need to reiterate the need for confidentiality. And order of interviews, there's no particular hard or fast rule as to who you should interview first. Ordinarily, you would probably wish to interview your witnesses first, so that when you come to meet the person facing the allegations, you have a lot of the information that you can start to ask some questions around. However, in an investigation, that doesn't always go to plan, because it will depend very much on availability, because you have to give the individual facing the allegations the notice of the meeting, and sometimes you will do that first so they can arrange their union representation, and sometimes things can go slightly awry with the witnesses. But don't worry if that's the case, because you will always have the opportunity to speak to the individual facing the allegations again if you need to, because something's been brought to your attention by a witness that you hadn't met prior to meeting them. I hope that makes sense. There is no hard or fast guidance on it, and as much as possible, it would depend very much on the circumstances of the individuals as you move through the investigation. Undue influence, I think, again, goes back really to, I mean, it's mainly for internal investigators, but as an external investigator, you can sometimes find that directly or indirectly, the commissioning manager will try to ascertain where you stand with things as it stands, what your feelings or thoughts are. They may well say something to you they don't even realise could be seen as exerting influence. So I think it's just really important that the investigating officer sticks to their plan, is very aware of what people are saying around them within those meetings, and just keeps everything on the record as much as possible. Our advice to an investigating officer is very much not to provide an assessment of where they're feeling it may go, because the pendulum can swing. So you've just heard me say that often you'll interview all the witnesses first, but then if you're asked to give an opinion as to where you are to the commissioning manager and you haven't spoken to the individual facing the allegations, your feeling at that point is going to be skewed in favour of the witnesses. So just be really mindful, and don't I would say don't ever endeavour to do that. You can give them very factual updates. I've got 3 more witnesses to speak to, or I've still got to meet with the individual concerned, but just hold back off giving any kind of information as to whether you feel it's going to move to disciplinary action. And I would certainly say, please do not endeavour to try and organise a disciplinary hearing before the report has even been shared with you, which we do sometimes find happens. But there will be an audit trail, and if that audit trail is ever shared, then it will really show the school and trust as having made a decision before the investigation has even concluded. So that's a real word of caution. Be cautious of language used in interviews. So just picking up George's point about open-ended questions, etc. We're not going to go into huge detail around questioning today. This is very much a kind of journey through the disciplinary process. But as an investigating officer particularly, really think about the language that's being used all of the time. Are the witnesses using the same language? I.e., does it feel like there's been some collusion? You may not be able to prove it, but it may be that some of these witnesses have been subjected to undue influence, and you need to be very mindful about that, particularly when the allegations are very serious. Are the other employees protecting the employee rather than protecting the children in the school? And I think that's something we have to be really cautious of when we're going through those interviews and we come to review everything we've collated to date. And I think just going back to Ada's point about unions sometimes, being quite assertive, I think as an investigating officer or even as the commissioning officer, be professional and respectful, but ultimately stand your ground. So what evidence is good evidence? Obviously, anything that's written down is good evidence because you're not basing a judgment on people's opinions. So anything such as emails, documentation, original statements that have been collected as part of that preliminary fact finding, because original statements made on the day or the day after everything has happened are so powerful. When you come to meet someone sort of maybe 3 to 6 weeks further down the line, memories have faded, and that is the chance where people have started to talk to each other. So they're starting to think about what someone else has said to them and repeating that rather than it being what they've actually witnessed. Student statements is an interesting one. We would say, unless Ada says any differently, we would say collect them as soon as possible. And the reason for that is because if it does become a police matter, the police will stop you in your tracks. And if you are then, it goes through a police process, which can take a few months, goes back to the LADO to come back to the school. Often the school are investigating it several months later, and it is absolutely going to be too late to be speaking to students about what they have witnessed. So I would say get those statements.
Yeah.
You don't have to do anything with them if the police have told you to stop, but you will be in control of those statements. Have you got anything else to add on that,
Yeah,
Ada?
I would just add, depending on the age of the children, sometimes we're dealing with primary school age children. I mean, they're not going to, if you don't speak to them in the moment, they're not going to remember, memories fade. And particularly very young children, they won't recall what happened yesterday or a week ago. So that's really important. Just on the speaking to students point, sometimes unions or the staff member who's the subject of the investigation will ask for the investigator, whether internal or external, to interview the students or the children. That needs to be considered very carefully. Primarily we need to think about the impact on the student versus the benefit of them being interviewed. So if we've got these statements from the students when the incident first occurred, arguably there's no need to go and re-interview them, and that could cause upset or harm to them if the matter that we're asking them about isn't actually significantly in dispute. So we wouldn't ordinarily encourage the interviewing of students as part of an workplace investigation. If it becomes necessary, it should be a member of staff known to them rather than particularly a stranger, an external investigator. So we do have to be mindful of their interests and safeguarding them at all times.
Yeah, absolutely agree. And I think as well, it might sound quite obvious, but especially with primary school children, if you have someone that's actually writing a statement on their behalf, just make absolutely sure that there's something on that statement. Say, Penny Reid has taken a statement using the words of student A, just so that it indicates that they are the words of the student, but obviously someone else has written them up. And CCTV, we have already touched on this, but it is often very time bound. It is such an effective tool to be used as part of an investigation. But if the investigating officer is reliant on that CCTV or has viewed it, then we have to make provision for the employee themselves and or their union rep to also watch that CCTV so that they can again put their perspective across as part of the investigation interview. And then moving forward, we're going to assume that everything's been collated. The investigating officer's finished speaking to everybody that they want to speak to. they're going to complete and conclude that report. Now, there always is going to be implications arising from conducting an investigation. And as I said earlier, the key finding for the employee in particular, but also the school and trust, is there a case to answer, and is there a recommendation that it proceeds to a disciplinary hearing? Because that will trigger off another set of events in terms of what that looks like. There may be some other consequences for you to consider, such as recommendations might involve some learning for the school. So that could be, George, as you said, perhaps a recommendation that the policy is reviewed, or actually that the policy needs to be followed in its entirety. It can undoubtedly cause pain for everyone that's involved, so please don't underestimate that. There might be some restorative work that needs to take place. Now, there may be some referrals to outside agencies such as the DBS and TRA for teachers. However, what we will say, and that could be a recommendation the investigating officer makes, however, we would say do not do any referrals until you've exhausted that disciplinary process, which includes any appeal. Because if it is overturned on appeal and you've already set the ball in motion with a TRA or DBS, it's out of your hands. As soon as you've made that referral, the DBS and TRA take it over, so you can't then sort of retract making that referral. There are some risks associated with unexpected outcomes, particularly valid when you're getting an external investigator to investigate, because they may well bring things up that you had not recognised within the school. And not taking actions on recommendations. It's really important, especially if you've invested in an investigation report, is to really read and review those recommendations, because often they can be really, really significant learning, which can set you on a path, in the future that's really helpful. So we've touched on this already, naturally, as part of the other part of the presentation, but in addition to outcomes, the investigator can also make observations, as we've said, or recommendations about policies and procedures. They can make observations or recommendations about governance or effectiveness of leadership. They can also potentially touch on culture in a team. And this is really more for a grievance. They can sometimes conclude that the grievance has been raised maliciously. That would not technically happen with disciplinary. It's not exceptional that it would happen. It might be that someone says, well, the low-level report has been made maliciously, but ultimately the outcomes would say there's no further action to be taken. So it's not often you would see that as an outcome for a disciplinary. And as we've said, touched on already, the investigating manager had no power to issue a sanction or to decide or act on the outcome of the investigation. They are there only to make recommendations. So ordinarily they would present their report and their findings to the commissioning manager or officer. We use the term interchangeably, and they are often asked to attend any formal hearings so that they can report their findings directly. And actually, as Ada said quite a while ago now, the union and or employee and the panel can ask some questions about their report. Now, this is often where you find the investigating officer gets quite a hard time, because sometimes the employee will defend their case by suggesting the investigating officer has been impartial or, has not investigated thoroughly. So, but that is something that's open to you as a school and as a trust, especially if you've asked someone externally to do that investigation, so they can support the commissioning manager at a hearing. We talked about the burden of proof being on the balance of probabilities, and it's the same as in claims and employment tribunal proceedings. But findings are based on the information and documentation that has been given to the investigator at the time. So what we have seen, and I think it's happening more frequently now, is potentially the employee doesn't take the matter particularly serious at investigation stage. So they don't provide information that they're going to rely on. And then when they're invited to the disciplinary hearing, all of a sudden as a panel, you're getting a great big pile of papers. And that's fine, because that's their opportunity to present their case as well. But be mindful that the chances are that the investigating officer has not had access to that information. It's only been shared at this stage of the process. And once the report has been received, it's for the commissioning manager to undertake their due diligence and decide whether, on the balance of everything that's been presented to them in that report, they are happy with the recommendations. If they are, and the recommendation is to move to next stage in terms of formal disciplinary, then the commissioning manager with the support of HR will action those next steps. Only the decision panel can determine whether that wrongdoing has taken place and issue the appropriate sanction. So broader obligations arising from the investigation outcome. The outcome may trigger obligations including to external bodies, and we've made some reference to these already this afternoon. So the Academy Trust Handbook may need to be considered, particularly if it's in relation to financial misconduct. The DfE, Ofsted, the diocese, the local authority by way of the LADO. We have statutory obligations in relation to keeping children safe in education, and we've touched on TRA and DBS. And as we said, please don't make any referrals until the process has been exhausted.
Yeah, just to add on the referral point, often it's argued by employees and their reps that if you do the referral at the disciplinary stage before the appeal, that the appeal has been predetermined. You've shown your hand. You've made the referral. That means that the appeal is hopeless. Even though that's not the case, that's the message that's sent. So even where the investigation report includes a recommendation to make such a referral, do hold off until the internal process has concluded and the appeal has been disposed of.
Yeah, and so we've gone through that process. The disciplinary hearing has been arranged, and these are some kind of pointers and guidance in terms of what the arrangements for that disciplinary hearing will look like. So if it is progressing to disciplinary hearing, please follow the policies. We've heard George saying today, sometimes if it goes to appeal, there have been steps where perhaps the policy hasn't been followed in its entirety. We would say please follow in its entirety. If there is something missing from your policy or something seems slightly obscure, you can always refer back to ACAS guidance. What is ACAS guidance telling you about a disciplinary procedure? Provide adequate notice. This ordinarily tends to be 5 working days, but again, follow your process and policy in case you offer more than 5 days. Provide all appendices, and this is with disciplinary hearings, provide all the appendices that have been noted as part of that investigation report. It's really important that what the panel get to see, the employee also gets to see. So we must make sure the panel aren't given additional paperwork that the employee hasn't seen. If the policy provides for a panel, so sometimes we hear of a hearing officer, so it could be a head teacher that's the hearing officer, but if the policy is saying that you are going to panel, i.e. there's 3 people, please make sure that you choose a chair in advance. I have been known to support panels, and the 3 people have kind of had this almost semi-argument between them because nobody knew they were going to be chair, and obviously being chair means fundamentally if it goes to a tribunal, the chair may be invited as witness. So it's just good to kind of agree that in advance so the chair isn't walking in not knowing that they're going to be a chair. Ensuring appropriate space is booked with separate rooms for the employee and their union rep and the school stroke investigating officer. If the member of staff has been suspended, and this is true of the investigation interview stage as well, it might be appropriate to consider a neutral venue. Again, it will depend very much on the circumstances of the suspension, but often, especially if it's safeguarding allegations, it would be really wise to consider a neutral venue. But either which way, make sure that you have the main room for the actual hearing and 2 separate rooms so that the union rep and the employee can talk, and the investigating officer and school commissioning manager are able to talk as well. Both parties enter and leave the room together. It's really important that we are mindful of that. Most people do know that that is the case, but sometimes with the emotions of the hearing, some people can sort of stay in the room if someone else, if the employee is leaving with the union rep. So just make sure that everyone's mindful of that so you can remind each other of that if necessary. Provide the chair with a script. It's nerve-wracking for chairs and trustees or directors as well as it is for the other parties. So just having a script that reminds them of the different stages can be really, really helpful. Now, some policies advise that the panel or the hearing officer adjourn the meeting, ask the parties to wait in their separate rooms and then bring them back in to give them the decision. This can be navigated at the start of the meeting. So if your policy determines that, and actually as a panel, you want to undertake your deliberations without any pressure of people waiting, then just navigate that at the start of the meeting and ask whether the employee and their union rep are happy for all parties to leave, and a phone call will be made to give them the high level decision followed by the written outcome. And often we find that that's a really useful way of the panel not feeling under pressure. But the difficulty is if the panel deliberate and take 10 minutes to say they're going to dismiss an employee and the employee's waiting, then of course the employee at appeal stage could say, well, the deliberations were 10 minutes, you'd already made your mind up. So have a think about that if your policy does state that you should adjourn and then call them back into the meeting. And provide the letter within the specified time frame. So, I just think I've just gone back, sorry, I've jumped ahead of myself. Provide the letter within the specified time frame. So it's always really useful to check what that time frame is going to be. Your HR support, so there will normally be a HR advisor to the panel. They should be on top of those kind of pieces of information, because that is often a question that will be asked by the employee, when can I expect to hear? And with that outcome letter, please do provide the opportunity for the employee to appeal if a sanction is to be issued. So even if a sanction is a lesser sanction than dismissal, still give them the opportunity to appeal, because they still may feel that even a written warning is unfair under all of the circumstances. I can see Ada's wanting to come in.
Yeah, I was just going to add that we do have agendas for hearings, panel hearings and appeal hearings. I don't know if it would be helpful to share those with you, but there's nothing preventing you sharing an agenda for the hearing in advance with all the parties, and that's really helpful for any chair to basically control proceedings, and the panel to understand how the hearing is going to go and everyone's clear on what's going to happen. So that can be really useful beyond just providing a script to the chair. And on the outcome, if it's the case that you can't meet the timeframes in your policy, obviously it's recommended that you do. But if you can't, because people have full-time jobs, they've got family commitments, 5 working days isn't really realistic, particularly in a complex case, then your policy should have provisions saying that if you can't meet that time scale, you will write to the individual to tell them that you can't provide an outcome within that time frame, and give them a revised time scale, and that's perfectly acceptable. So it's not fatal if you breach the policy on that particular point, as long as you're communicating with the individual. But strictly speaking, we should try and meet the timescales in the policy.
Okay, so we're moving now. We've issued if we talk about our fictional case, we may have issued one of the higher sanctions. I don't want to assume anything at a later stage, but a sanction has been issued to Adam and he has appealed it. So the appeal stage is a very similar process used at the disciplinary hearing. Again, as Ada said, we have got appeal agendas. However, the exception is that the employee will go first. So they will be presenting their case because this is their appeal. They must present their grounds of appeal, and this is where a chair, sharing the agenda in advance and having an experienced chair can really help, because this is not designed to rehear their entire original case. Sometimes you do have to draw them back to the grounds of their appeal, and that has to be done quite carefully, because you don't want them at a later stage to say they weren't listened to, or they were sort of told to not say that. So it is a fine balance, but it is very much to hear the grounds of their appeal. And an appeal also is a final opportunity for the school and trust to right any obvious errors. So actually, if at appeal stage, I guess what I'm trying to say is, don't necessarily feel an appeal stage is to rubber stamp the previous decision. If there is something as a panel that you absolutely do not agree with, or there's something that has not been considered, and the grounds of appeal are substantiated, do not be afraid. I know sometimes that can create some pain, later down the line, but that is your role as an appeal panel. So it is an opportunity, it is the final opportunity to kind of right any obvious errors that may have occurred throughout the process. Ensure the employee does feel they've been listened to, but do ask any necessary questions. Ultimately, this should be the first time you've seen this case and this paperwork. So you may well have questions that hadn't been asked at disciplinary hearing. So if you do need to ask something for clarity, you have absolutely the right to ask that of the employee. And then again, as before, issue the outcome letter within a time frame stated in the policy, and added to that Ada's caveat that if for any reason you can't and your policy allows you to, just make sure that you're keeping the employee updated, or ex-employee as may well be at that time, of the kind of, you know, renewed time frame, as in we're going to take another 5 days, but we will have it with you by such and such a day, just so that you're communicating with them at every level. So what happens after the panel hearing and workplace procedures? The panel will make the decision either at the hearing, we've talked about this one already, the employee will have the right to appeal the panel's decision, and they should be given that right. Sometimes you could be notified of strike action. So these are different types of things that can come your way after the decision has been made. You may receive a seeking assurances letter from the DfE if the employee complains to them. You may even receive contact from Ofsted, the LA, or the diocese. You may sometimes, I think Ada touched on this right back in the sort of earlier slides, you may even receive a letter before action from a solicitor acting for the employee. This is sometimes designed to be quite a threatening tactic, but again, seek advice. Don't be frightened off, just seek advice, and then we can support you as appropriate. You may receive contact from ACAS informing you that the employee has commenced ACAS early conciliation. They can do this at any time and don't need to wait for the panel or the outcome. However, the first time you normally hear of it does tend to be from ACAS. The employee doesn't tend to tell you they're going to do that. Or notice of a claim by post from the employment tribunal. If any of those happen, any of the 3 bullet points, well, fundamentally the 2 bullet points, because if you are with RPA, they will normally ask you to give a copy of your ACAS early conciliation or your claim, the tribunal claim for the employee, in order to initiate that cover. So if you hear anything from ACAS or the employment tribunal, notify your insurer straight away. If it's RPA, then obviously they will give you, hopefully they will cover you and give you a claim reference. And if it's any other insurer, I don't know what Ada's thoughts are, but sometimes they can take slightly longer to come back to you to let you know that you are covered. But it is really important you do that very, very quickly, because as soon as they've notified you that you are covered, that will start to pay your legal costs. But I'll pass over to Ada for any more information on that one.
Yeah, that's right. I mean, our recommendation is always to go with the RPA. It's by far the most generous cover for schools and MATs. The commercial insurers may well be cheaper, but they are much slower, and ordinarily you would have to use their in-house solicitors. So on the face of it, they might seem cheaper, but in the long run, in terms of what a school and MAT need, from the majority of our clients, they've benefited from the RPA the most.
Okay, and then possible interventions from external agencies. So obviously we've touched on LADO, Child Protection Services, social services. The police may well get involved at a later stage. Ordinarily they tend to get involved at the early stage, particularly if it's to do with safeguarding children. Fraud is probably a latter stage for the police to get involved with. The DfE, JCQ, so is it an example, the allegations an example of exam malpractice, the regional director, sometimes health and safety executive, again, depending on the circumstances. The ICO can sometimes get involved. So all of these people may come with some interventions for you, either during the process or fundamentally towards the end of the process when things have been concluded. So it's always best to seek advice if you get any kind of communication from them and you're unclear about next steps or how you should respond.
Yeah, and I think we've seen an increase in other regulators or regulators of other professions becoming involved. So, for example, where someone's a school counsellor, they're regulated by a particular body. Those external agencies have now, started making their own inquiries. Where someone's a physio internally, again, they're regulated. So it goes beyond just the TRA.
Absolutely. So I'm going to pass over to you, Ada, to do some slides on settlement agreements, etc.
Yes, thank you, Penny. So I wanted to talk about this because there was an update to the Academy Trust Handbook a couple of weeks ago, which I'm sure you're all aware of, but it's quite a significant update relating to special staff severance payments, and that is usually a payment made to a member of staff outside of their statutory or contractual entitlements when they're leaving public employment. Now, just going back to the previous slide, I mean, it's not controversial that keeping children safe in education provides that settlement agreements should not be used where there are safeguarding allegations or to prevent a school from undertaking their investigations into safeguarding allegations. Now, ordinarily, we will see settlement agreements used at the very early stage where it's just an initial disclosure of information. We don't know much about it. We've done an initial fact finding, but we can't really see what's happened. And we might be open to a settlement agreement. But where we've sort of progressed, where we've determined that there's a formal investigation required, or indeed carried out an investigation, and it's been decided that breaches have occurred and there's a disciplinary case to answer, I think you would struggle to enter into a settlement agreement without first clearing it with LADO. But either way, whether you're using a settlement agreement or not, it's crucial that it doesn't in any way fetter your rights as an employer to comply with your legal or regulatory obligations, which would include referrals to the TRA and the DBS, and also referrals to the LADO, the police, and so on. And any reference that's agreed with the employee should disclose substantiated safeguarding concerns or potentially incomplete investigations, depending on how far along we are. The change to the Academy Trust Handbook that I just mentioned happened on the 22nd of October. And I say it's a significant change because it requires that where a special staff severance payment is being made and a confidentiality clause is proposed, you must seek DFE consent in all circumstances, irrespective of the level of the payment. Now, that change means that the settlement agreement is less attractive to the employer. It means the individual, if we're going to remove the requirement of a confidentiality clause, the individual is free to disclose that they were offered a settlement agreement, paid off, whatever might have happened. And that sends a really dangerous message to others that, one, you can misbehave potentially and be paid out, or that anyone who threatens the school or trust with a claim, complaint, grievance, whatever it may be, you will be quick to pay them out. So this requirement means that if you want to do a settlement agreement to exit someone and tie them into confidentiality obligations, you have to seek DFE approval. I've set out there a table that shows you when you may not be required to seek DFE approval, and that's where you are making a staff severance payment but not including a confidentiality clause, or you're not making a special staff severance payment, so all you're paying is notice and contractual entitlements. In that case, you can include a confidentiality clause and DFE consent is not required. And then, of course, where there's no staff special severance payments and no confidentiality clause, then DFE consent is not required. All of that, of course, assumes that you've complied with all the other requirements of the Academy Trust Handbook. So query, I suppose, whether if someone has disciplinary allegations against them, why would you pay more than contractual and statutory entitlements? The reference might be worth more to them than a sum of money. And in that scenario, you can insist on a confidentiality clause as long as you're saying, well, actually, we're not paying anything above and beyond your notice, but we will give you a reference and, this process will go away. Similarly, query, do we just follow through with the process and wait for the person to take it further? If they take it further, it won't constitute a severance payment because they've already left our service if they've been dismissed. And in that case, we can pay them off potentially if there's merit to do so and include confidentiality clauses without having to seek DFE approval. If you decide to go with the first line of the table, which is pay the staff severance payment and impose a confidentiality clause and wait for DfE approval. There's a number of issues with that. One is we don't know how long it might take. Meanwhile, your process has been kept on hold. There is an obligation to progress investigations and disciplinary matters without unreasonable delay. And I don't think a tribunal would accept that delaying it while you wait for DfE consent for a settlement is a legitimate reason. It also means that the DfE will look at the transaction as a whole. So they're not just going to look at giving consent for the confidentiality clause. They're going to want to understand the entire deal and how you've arrived at that decision. So they will scrutinise the entire transaction. And of course, they may refuse approval. Meanwhile, you haven't progressed the internal process. So it's really important to be aware of this change. And certainly if you're looking to do a settlement agreement with someone, do reach out to us so we can steer you as to what might be the best strategy to deploy, because ultimately we would want to tie the person into confidentiality if we can. And what that may mean is just following through with the process and seeing if they challenge it further. There was another development regarding settlement agreements on the 1st of October under the Victims and Prisoners Act, and that set out certain disclosures that are permitted even where someone has entered into a confidentiality clause or a non-disclosure agreement. And I've listed those there and put a link to the guidance, but essentially no settlement agreement should prevent these types of disclosures. And if they include a clause that does do that, then such a clause will be unenforceable. And back to you, Penny. Does anyone have any questions on that change? I mean, I think the sector response initially was this is outrageous, but I think people understand it now. They've gotten on top of it. So I don't know if anyone has any questions on that, or is the change pretty clear? No. Okay. Penny, over to you.
I need to unmute myself. I muted myself while Ada was talking. Sorry. So we touched on this.
Kate's got a question.
Ada, I'm sorry. Excuse me, apologies. I couldn't put my hand up quick enough or find the right button at this time of day. So I do apologise.
That's all right.
You talked about changes that have been implemented via the Academy's handbook as a straightforward, allegedly, voluntary aided school. I assume that change hasn't been implemented.
No, not for VA schools, only for organisations subject to the requirements of the handbook.
Okay, lovely. Thank you.
Yeah. Penny.
Okay. So we are going to touch on staff grievances, just because, as Ada referenced earlier on in the training, we sometimes find that grievances and disciplinaries can work hand in hand, only because sometimes the subject of a disciplinary investigation can sometimes raise a grievance as a means of delaying or avoiding disciplinary process. Yes, we do not want to make any assumptions. We can only give you the benefit of our experience when we see this happening. So things to consider are very much, please do check your policies. What do the policies say and how can they help you in this situation? Is it necessary to stay the disciplinary process pending a grievance investigation? Or, as Ada referenced earlier on, is there a sufficient overlap in evidence, witness, subject matter, such that the grievance can be investigated as part of the disciplinary investigation? So we would always say, if that looks to be the case, please do come and get some advice so that we can advise you further and say whether actually that is the right course of action under all of the circumstances. Regardless, follow the ACAS Code of Practice on disciplinary and grievance procedures at all times. And please, as I said, please do come to us to gain some clarity and manage the situation effectively. We are seeing this more and more because a lot of schools and trusts will sort of put on hold the disciplinary process because the individual has linked the grievance enough, but not enough that it could be merged together. So it's often, I think it's often a tactic the union can ask the employee to deploy. So we are seeing it more and more. But if you're unsure, please do seek advice. So staff sickness absence, again, Much like a tactical grievance, it's not uncommon for the subject of a disciplinary investigation to be signed off with stress. Often they will cite that it's workplace stress. So again, please do check the policy, because sometimes we find that policy suggests that if it's workplace stress, that an OH should be done straight away anyway. However, OH can also be a really effective tool to help us understand whether the employee is fit to attend those workplace meetings, i.e., are they fit to attend an investigation meeting? Again, sometimes this can be tactical, but also please don't make assumptions, because we all understand that being subject to a formal workplace investigation can be really stressful. And regardless of what those allegations are, you still do have a duty of care as an employer in those circumstances. So if the employee is signed off work by the GP, they will often say that they're not well enough to attend an investigation meeting, or if matters have progressed to a panel hearing, that again, they can often cite that they're not fit enough to attend a panel hearing. As you can imagine, that can cause serious delays to the process. Added to that, if the individual is suspended from duty, then obviously that there is a financial aspect to that for the school and or trust as well. So things to consider: how can we still proceed with the process, but what do we need to be considering? So be proactive in managing a sickness absence, and please do offer support. So if the individual is suspended, they will have a workplace colleague or contact, so please do make sure that they are still reaching out to them as normal. They can be referred to OH, as we've said. You have an employment assistance programme, or most schools and trusts do, so please do reiterate that signposting. Does the EAP provide counselling sessions? Have a look at what you can provide to that employee as part of your wellbeing initiatives. Maintain the momentum of the process by offering them alternative ways of participating. So can we offer them a remote meeting rather than in person? Can we offer them the opportunity for their representative to attend on their behalf? Sometimes we have been asked whether they can allow a second companion, i.e. a family member that can help them just for moral support. A neutral venue, we've touched on that previously. Agreeing an agenda in advance. Sometimes we've had requests from unions to say, can the questions be sent to them in advance if they're still at the investigation part of the process? Be patient with them. All of the things above can be considered. If it's tactical, you will probably find that they'll come back and say, no, I'm just not fit enough. So we always say avoid proceeding in their absence, because it should absolutely be the last resort. And if you are considering doing that, please do so with great caution, and please, again, do seek advice, and we can either give you some alternative reasonable adjustments to consider, or we could support you with that, using that last resort if we know that everything else has been exhausted. Understand the options available to you. I mean, obviously, it's not going to support the employee to continue being off sick with this hanging over them. And as I said, as a last resort, you can proceed in the absence. At investigation stage, when you tend to do that, they do tend to come to the hearing. However, each circumstance, each individual is very different. So it's just that we need to be mindful that sometimes this, and again, Ada, we're seeing it more and more, aren't we, where this is becoming a real barrier to concluding that process.
Yeah, absolutely. But we have had success in helping clients progress matters where these sorts of delay tactics have been deployed. So it's possible, but it still takes time. It's not a sort of an overnight success, as it were. And as Penny said, sometimes having exhausted all possible ways of engaging the individual, particularly at the investigation stage, you're fine to proceed in their absence, because the ACAS code does include flexibility at the investigation stage. It says sometimes an investigation may be a fact finding on paper, and sometimes it may involve a meeting with the individual, but it doesn't say that it has to be a meeting every time. Now, of course, your policies will go above and beyond that and recommend an investigation meeting, but there's only so much you can do to try and engage the individual. And as Penny said, once they've been warned that you're going to press on, they will ordinarily, at the very least, send written representations.
Okay. And data subject access requests, again, we can find these, I would say they happen more often with grievances because, or as a pre-action to potentially the employee or ex-employee taking a tribunal claim out against you. However, we just have to bear them in mind because they can sometimes come out of the blue as part of a formal process. So this is a request for an individual's personal data. They can often raise them as a means of further delay, or because they are under, they're under a genuine belief that this has all been a little bit of a setup, or there's people talking about it, conspiracy theory, exactly that. Or they may genuinely feel that by making a DSAR request, DSAR, they are going to uncover a procedural impropriety. There are a number of reasons why they may make one of these requests. Now, the timescales for response is 1 calendar month. If the request is complex, you can extend by up to 2 calendar months, but that should be notified. You can notify them that you're going to take an additional 2 months within that first calendar month. So the individual should be aware within that first calendar month as to when they can expect to receive the information from their DSAR. You must consider whether any exemptions apply, i.e. is there third-party personal data? Is there the harm exemption, the child abuse exemption, or is there legal professional privilege? Now, our school support team are experts in this area. So again, if you get a complex DSAR or you want some very bespoke advice, depending on the circumstances of the request, please do reach out to them and they will be more than happy to support you through, especially with the exemptions as to what you should or shouldn't be sharing. Is if the request is felt to be manifestly unfounded or excessive, you can go to the ICO guidance. But again, I would suggest you reach out because there is a really high threshold for the ICO considering something to be unfounded or excessive. And ultimately, the requester still can complain to the ICO if they are unhappy with the way you have handled their request. So again, it's just something to be mindful of. We tend to find them more with grievances, as I said, but that's not to preclude them coming your way as a result of disciplinary allegations and or a formal investigation.
Yeah, I think I'd add to that when you are going through this process, be mindful that any communication you're creating may well be caught up by a DSAR or disclosure in any future litigation. So try to avoid internal emails, written communications, particularly that are adverse or unfavourable to the person or aren't very complimentary. If you need to have those sorts of discussions, try and keep them to the phone, something not tangible that's potentially disclosable. But ideally, just maintaining the integrity of the process and not engaging in those discussions until it's run its course is probably the best approach. George.
Can you say a couple of words about legal professional privilege, because that, as I understand, got a little bit more complicated in recent years in that you have to disclose certain things. Could you comment on that?
So legal professional privilege is two-limbed. You've got legal advice privilege, and that applies only between lawyer and their client. So it won't ordinarily apply between the client and, for example, a HR consultant or a HR advisor unless they are legally qualified. And that covers all communications between the lawyer and their client where their dominant purpose is to seek legal advice. There's a second limb to legal professional privilege, and that's litigation privilege, and that's much broader, and that applies to not only communications between the client and their lawyer, but can also be between the lawyer and a third party or the client and a third party, where its dominant purpose is in anticipation of actual or potential litigation. So, for example, if you are talking to someone internally, whether it be your HR director, your CEO, or externally, such as your HR consultant, about your concerns that an individual may bring a claim or about a claim that has already been brought, or even ACAS early conciliation, that may be caught by that second limb of litigation privilege. ACAS early conciliation discussions about ACAS early conciliation internally will probably be covered by the without prejudice rule as well, because they do relate to settlement. In terms of kind of losing privilege. Legal professional privilege only attaches where the communications are confidential. So what that means is the more you share the advice internally or potentially externally with your external advisors, there is a risk that privilege is waived. And the most dangerous part is you can't waive privilege in part. If you've waived legal privilege attaching to one piece of communication, then the case law suggests that you've waived it in the entirety of that matter, which could be incredibly damaging to the employer, because it may mean that we need to disclose all our advice in that matter. And the advice may well contain, things that aren't very nice about the individual, strategy, why we're saying you should dismiss them, what the risks are, what your prospects of success are. So, it really needs to be handled carefully. Now, there's nothing preventing you sharing our advice internally, as long as you only share it with a limited group of people for whose benefit that advice is given. So, for example, the head teacher, the CEO, potentially directors, because ultimately the liability sits with them as the people in charge of the business, ultimately with final responsibility, and who are required to manage the risk. But sort of routinely sharing our advice is definitely advised against. We do have a briefing note on that too, which we'll send to Debbie. We'll send everything to you, and then you can circulate if that's okay.
Yeah, that's fine. Thank you.
Was that okay, George? Did you have anything?
Yeah, that's fine. Yeah, just a concern, obviously, if you enter into legal consultation, that you're not stepping over the boundaries. But yeah, we're subject to the professionals, I guess.
We've got a hand up. Yes.
Hi, I just wanted clarification. Sorry, there's a Hoover going on in the background. I'm just thinking about between members of staff. Can WhatsApp groups and things like that be used in a SARS?
Potentially. We've had members of staff raise SARS with knowledge that these groups exist. Now, there are complex arguments around it. Is it a device issued by the employer? Has the employer, as the data controller, actually have control over it? Does the employer endorse the use of WhatsApp for workplace discussions? So it's not an easy answer. And yes, it may well be caught depending on the circumstances.
Okay. So refusal to cooperate and union challenge. We talked a little bit about union challenge today, and we talked a little bit about employees facing the allegations, perhaps not cooperating for a number of reasons. But sometimes the staff member will simply refuse to cooperate. So they will be obstructive, and they may even breach further policies, engaging in further unacceptable conduct. So an example of that could be talking to anybody about the allegations they're facing, or even, when you're delivering the news that they're facing allegations, they can actually get quite difficult or behave inappropriate towards you or another member of staff. Now, you may also face union challenge. They might object to an investigation. They may even go as far as threatening strike action, but we'll go back to the original reason why you started the investigation, and that it's a fact-finding stage only at this present time. And stay firm. That's our advice, is you listen, but obviously these are the reasons why you have to progress down this route, and you can just reiterate that at that point it is an investigation. They are difficult types of situations to manage, particularly as you're managing them around your very busy day jobs. And emotions, as you can imagine, are running very high. So things to think about. We've talked a lot today about the policies, but what do your policies say? What help and guidance are your policies giving to you? Is it reasonable for you to expect cooperation? Well, yes, because the workplace policies apply to all staff. Is it a reasonable management instruction to cooperate and attend the investigation meeting? Again, yes, it is reasonable for you to expect them to attend a meeting that you feel is appropriate and important. Does the conduct give rise? So if they have conducted themselves in a difficult way, does that give rise to further disciplinary allegations? But we would urge caution with that one, because what you may find is that a grievance will come your way and they may suggest that they are actually at that point being victimised. Always always be the reasonable party. The more reasonable and accommodating you are, the more unreasonable the union rep and or their employee may present themselves to be if they persistently refuse to engage with the process. And a point to add here, as an investigating officer, it is always really useful to make notes in the investigation report if you have tried to arrange meetings on several different days. You know, that can form part of the kind of procedure of your process so that you have it noted down. Make it clear that you are committed to the process and you do have an obligation to follow through with it. Sending them away or just sort of listening to their objections without due consideration will not make the problem go away. And if it is a safeguarding issue or conduct, then you obviously have safeguarding obligations to manage. Call upon external guidance when you're trying to reason with the employee or their representative. As Ada said, we are always there. You have a retainer, so if there is something, you know, if you've had an email from a union rep that is not sitting well with you and you want to seek advice, please do come through to us. Focus on ACAS guidance. Their guidance is incredibly detailed. You will often find the union quote that, but they will often quote tiny pieces of a bigger paragraph. So it's really useful whenever that happens to just go back to the entire body of that paragraph to get the full spirit of the meaning. And you can also go through to the union's own website or literature, because often what they're saying on their website can sometimes be very different from what the actual union rep is saying to you. If you can always show that you're complying with the ACAS code of practice or good practice, then it's really difficult for them to continue to challenge that position. Listen to what they are unhappy about, though, and consider whether there is anything within their unhappiness that you can accommodate. So if some of their responses are either narrow or their requests that you can facilitate quite easily, you may consider that it's worthwhile to do so, whilst always considering, are we opening ourselves up to always doing this in the future? So there is a balance to be had, but sometimes just giving them a bit of leeway on one small thing can take the large thing away and it just sort of seems to vanish. And as ever, if you're in doubt or you just need some really bespoke support, because we're trying to give you as much of our expertise today as we can, but obviously everything will come down to the circumstances of individual cases. And we are seeing more and more these types of communications coming through, especially from union reps. Is there anything else that you wanted to add on that, Ada?
No, all good.
Okay. And just exploring common pitfalls, we'll go through this very, very quickly so that we can maybe open up the discussion as to your fictional investigation report. But one of the most common things we see is a lack of preparation from the outset. You know, it's almost, it could be a knee-jerk reaction, or it could be slight panic setting in, especially if the report has come from an external party. So just prepare, you know, if you have to take a day to do that kind of preliminary findings so that you know you're making the right decision about moving forward, then please do take that time. Offer reassurance to those facing allegations. Don't do that. So if you are saying you've got nothing to worry about, which I think is our natural, if you're faced with that employee sitting in the office, breaking down in tears, if we go back to Adam and the type of allegations he's faced, and you say it's okay, you've got nothing to worry about, you are not in a position to advise Adam that he has nothing to worry about. So I think be very, very careful. You can be supportive, but you can't make promises to him about what's going to happen further down the line, because we just don't know. So with someone like Adam, it's much more about signposting him to support. The investigating officer not being impartial. So have they had prior involvement? Should they be a commissioning manager? Just be very mindful of, so for example, they shouldn't necessarily, unless it's a very small business, be the line manager of the individual, because that can create issues of bias from the very outset. This was something George referred to. Be very careful about asking leading questions. So it's much more beneficial to ask open questions and open them up. And don't be afraid of silence. So sometimes, as an investigation officer, ask the question, allow that person to fill that silence, because often they will tell you far more than you need to know just because you've allowed them to talk. Be very careful about making assumptions. So we talked about making assumptions that, you know, a sickness absence could be tactical, or be careful of making assumptions that actually this happened and this happened when you haven't got evidence that suggests that that did happen. And then going back to the time constraints for collecting evidence, i.e. CCTV, sometimes witnesses go on leave. You know, one of the witnesses you may want to speak to may have just gone on maternity leave, so they could be off work for 12 months or coming up to leaving for maternity leave. Just think about all of those hurdles that could come your way while you're investigating, and do your utmost to kind of move those hurdles. And if you can't, for example, in the, you know, with the person going off on maternity leave, then just reference that in your report. Say there was one witness I was not able to speak to because they were absent from, you know, from school for a significant period of time, or whatever you feel comfortable saying, just so that the person reading your report knows that you have made that consideration. Not taking statements at the time of the incident, we've touched on this. Jumping to conclusions, not following the appropriate policy. Be very careful if you are ever in a position where you're the investigating officer. I think it's really careful to look at the language and tone of your questions. Are you implying guilt by the questions you're asking? Be very, very aware of your body language. You know, we know that sitting with arms crossed can tell that other person something very different from what we're meaning to say. Don't make decisions. I think some of us have that inclination that we want to fix everything, and, you know, yes, we found all this evidence, so therefore there's absolutely, you know, he needs to be dismissed, or that is gross misconduct. That's not what we're there for. We are there to say whether there's substantive evidence to suggest that this has to be dealt with formally, informally, or actually there is no case to answer. And I think the school and trust have to be prepared to learn from any mistakes. Sometimes I think we need to review investigations as a process of learning, particularly if we've got an external person that's coming in with a very, you know, open mind. They don't know anything about the trust or the school. They don't know about existing relationships. And actually, if they are saying this could be looked at differently, or we need to reflect on this policy or this practice, it's really good for the organisation to take note. And if you are involved, so going back to a question around, you know, should a head teacher be involved if they've been in a preliminary? If you know that you are potentially a witness, I think that's possibly the stage where you take that step back from being involved in the investigation, because you are possibly going to be interviewed as a witness. And I think that's where the lines can sometimes get blurred. So if you know that you are someone who's been stood in a corridor and witnessed, I think with Adam's case, you know, there was a senior leader that went to collect him and smelt the alcohol. At that point, that senior leader would know that they're going to be potentially a witness. So I think just be quite mindful about your involvement in the actual incident itself. So moving on to the investigation report. We shared the fictional investigation report with you. I hope if you have had a chance to read it, you found it interesting. I would just like to caveat it by saying there were obviously some areas in the report that we deliberately allowed for discussion points, if that makes sense. That would not be an example of an absolute watertight investigation. And we also have deliberately chosen I suppose a difficult scenario that schools find quite difficult to approach. Is that fair to say, Ada? That actually with staff that are potentially, you know, are being accused of smelling of alcohol, so there is a potential that they've drunk on site or they've come into school under the influence, we can often find that senior leaders, those involved with perhaps smelling the alcohol or witnessing, you know, behaviour that's potentially demonstrating being under the influence, can find it very, very difficult to report. I think that's fair to say.
I think that is fair to say. And I think what panels subsequently struggle with is if the person does have a substance abuse problem, particularly schools and trusts of a religious character, because obviously if someone admits to an addiction, there's a natural desire from a human perspective to want to support them and help them overcome that. So often it can be a moral versus legal kind of dilemma for a lot of schools and a lot of decision makers. And as you say, because the smell of alcohol, it's very difficult to prove. It's almost one person's word against another. Evidentially, it's hard for an investigating officer to ultimately determine which way the pendulum swings. So yeah, it can be one of the more challenging ones. So just for those who haven't read the report, the investigation concerns a science teacher who was carrying out a practical with the support of a technician and started acting out of character, slurring, swaying. Something went wrong with the technical, and the technician reported it. The teacher was removed from the classroom, sat down with the head teacher or the deputy head. There was a report of them looking drowsy, sort of struggling to stay awake. Someone did report a smell of alcohol, but others didn't. And then this investigation took place. The investigation did determine both allegations were substantiated. The one was the safeguarding of the children. Is that right, Penny?
Yeah.
And the second element was, let me just bring it up. What was the second allegation, Penny?
I can't remember off the top of my head, and I'm not
okay.
That he wasn't. I'm not going to lose a slide.
The first allegation was he was under the influence of alcohol whilst at work and on the school site, and the second one was he was unable to carry out normal duties and constituted a serious safety risk as the result of influence of drugs and alcohol. And obviously the context of being a science teacher in a lab, supervising a group of children, all of those are relevant. I'm just conscious of time, so I wonder if we just jump to the what would you do slides, Penny.
Yeah. Yeah, so this is more around scenarios that could happen. So as a panel, you are in your pre-meeting, so you've already decided, as Ada said, the findings are, the recommendations are, it's moving to panel. And you get to the panel, and in your pre-meeting, the commissioning officer comes in and wants to say hello and make sure that you're all okay and you've got teas, coffees, etc. But they then start to discuss previous informal concerns that they had about Adam with you. So we've got the red text there. I'm sorry, I didn't manage to make it fly in, but opening up to, even with what we've told you today or your own experiences, how would you address that issue or that concern potentially? We'll open it up to people to sort of chip in, I think.
It's down to the chair to control the situation. So politely ask them to leave.
Yeah. Absolutely. Yeah. And, interjecting straight away to say, look, to protect the integrity of the process, no discussions can take place until all parties are present. So it doesn't even need the clerk or the HR advisor. If the chair finds it difficult to get them to leave, they can ask for assistance. But really a firm no, thank you would be appropriate and sufficient. Now, I suppose a follow-up question is, do we then disclose to the employee and their rep that this was said to the panel, but that we've disregarded it? I suppose in the interests of transparency, potentially, but I suppose we'd have to weigh up what there is to be gained from that if we shut it down straight away and put it out of our minds. So I think that's a careful consideration. I'm not sure what the answer is. Does anyone have a view? Would you disclose it? George?
No. Not if it's handled in the normal process.
Yeah. No. Yeah, exactly. And ultimately a lot can be alleged against panels, appeal panels, decision panels, but a good line of defense is actually we're competent professional people. We know how to set aside irrelevant information and come to a reasoned decision, and that's fair enough.
Yeah, I agree. And towards the end of his presentation, so you'll have heard from the school and or the investigating officer, and then Adam's talking through his presentation, so he may choose to make a statement to the panel. he breaks down and confirms that he does have an issue with alcohol and he's now seeking help. He doesn't confirm or accept that he was under the influence of alcohol on the day in question. So how, again, would you approach that as a panel?
I suppose, is his admission of his alcohol problem enough to mitigate the potential misconduct such that we can trust him to be back in the classroom again? Because that's really going to be what it comes down to. And what I have an issue with is the fact that he won't accept that he was under the influence. So I think a panel would need to be really carefully advised on this really tricky situation, because ultimately, as we all know, those of us who work in the sector, is safeguarding of the children trumps all else. And unless we are satisfied that this person has been honest and upfront and is genuinely committed to recovering from their addiction, I struggle to see how we can safely put them back in the classroom. What I would like to see, and I've got experience of this from previous cases, is the person turns up to the hearing, you know, with evidence that they're on a program, that they've sought treatment from their GP, that they have been dry for several weeks since the dismissal. That would give me some confidence. Very often the employee will turn up and say, I have a problem and I'm going to address it. But when the panel asks them, what have you done between the dismissal and now, you know, sometimes a month has passed, they haven't actually done anything. And again, that doesn't instill the panel with confidence that this person's safe to be back in the classroom.
Yeah, I agree. And I think that's sometimes why asking some additional questions for clarity around what that help looks like. And, you know, how often have you been, once you start to ask someone those questions, if they're not accessing that help, they find it really hard to answer the question. So I think it's, I think Ada's correct, you have a really difficult decision to make as a panel, but actually how satisfied are you, you know, or are you going to be swayed by the sort of emotions and, you know, the outpouring from Adam, bearing in mind that potentially he has been under the influence in his role as a teacher with students in a science lab? Okay, so during the hearing, Adam's union makes several comments about the process. So he raises concerns about the delay between the allegations being raised and the conclusion of the report. He reinforces the point on several occasions that the allegations are not clear enough, and that Adam did not have all the information provided to him before the investigation interview. Therefore, the union rep is asserting that he didn't have the opportunity to respond to some of the details, so the process is unfair. So this covers some of the points we've discussed earlier on in the training session. So what would your approach be if you were on a panel and the union rep was saying these types of comments to you as a panel?
It depends really, doesn't it, in terms of where you are at the time. I think obviously you've got the red bits of your slide, but obviously you do need to listen and acknowledge what's being said. You need to review the timescales and the timeframes, see whether or not an adjournment to allow anything further to come out, remind colleagues and union reps that they've had the opportunity to present their information and their detail to the panel, because the panel can't make any decisions without their statements as well. So just kind of give them the opportunity to speak and remind them what they had a responsibility for bringing to the table as well.
Yeah, I'd agree. And, you know, don't be drawn into a kind of an argument almost with the rep and the employee. But ultimately, they had an opportunity to set this out in an appeal, in the grounds of appeal. So it almost kind of seems like a last ditch attempt, you know, to salvage this person's employment. You know, the panel doesn't necessarily need to get drawn into it. He's had his say. The panel can always review the papers after if they're not in a position to contradict it there and then. But it's probably a good idea to document it in the minutes and also the outcome letter, just as a brief paragraph along the lines of, this wasn't actually in your appeal, but it was made in the meeting. We've considered it and we do not accept that this is the case, or whatever the panel's findings are. You know, the panel might say, yes, there were delays, but we consider the delays to have been reasonable in the circumstances owing to your sickness absence or the availability of this person or that person. And also, as Penny has set out here, if the panel does identify procedural errors, it doesn't automatically follow that the whole process falls down and we have to bring this person back. We then have to ask, well, if that procedural error hadn't happened, would the outcome have been any different? And in most cases that concern gross misconduct, arguably, no, the outcome would have been the same.
And there's a lot of distraction is deliberate, and we have to look at the information that we have, the facts, the evidence, and that should be the overriding guiding force. Anything that is claimed, as you said before, it should have been raised earlier if it was a genuine point. Absolutely.
And yeah, spot on. And it takes a strong panel and a strong chair and a well-advised panel to take that position, because as I said at the start of the session, the unions can be quite persuasive, but actually when you drill down to what they're saying, they're wrong.
Yeah, I was just going to say what I think you've already just said then, to make sure that it is part of the considerations outlined within the outcome letter. So if it does go to appeal, at least it's recognised that was noted and considered as part of the decision.
Yeah, absolutely. Absolutely. Well, you're all pros now.
We've literally got a couple of minutes.
Yeah.
Has anyone got any questions that they haven't had a chance to ask us that we can use these last couple of minutes to respond to?
Penny, could I just ask about, to help perhaps at the first level of choosing the investigation manager, some guidance, because you said who shouldn't be, so for example, line manager, but what kind of guidance could you give to usually the head teacher picking somebody to be the investigation manager?
I think the head teacher needs to decide whether it's one of those complex matters that could be considered to give to an external. I think you have to make the decision, is it going to be internal or external? I think if it's internal, you need to have someone that's suitably senior, because ideally, these are serious matters that are under investigation, and hopefully you would have someone suitable. But I absolutely don't think, ACAS is really good on this point, because they recognise that smaller businesses just may not have the choice open. So in terms of that code of practice, there aren't specific stipulations, but what we would say is I would absolutely give guidance that if you know an individual has potentially witnessed something, they shouldn't be investigating, because that means that they can't be called upon to be a witness, and they may already have a bias towards something they may or may not have seen. Line managers is really difficult, because they will almost always have an existing relationship with the individual. And that could be a positive or negative relationship. We don't know. So again, are they going to be overtly harsh? Are they going to be seeking evidence that supports the allegation so that they can almost just get rid? Sorry to say it so bluntly, but that sometimes can happen with line managers. So I think someone of a specific seniority that can do a thorough job and that doesn't have, as much as possible, specific day-to-day involvement with that individual, that if it's internal, you can alleviate some of those allegations further down the line. There's been some kind of bias applied.
Yeah, the problem with the line manager is if things go wrong or there's no wrongdoing, that's what's established. The relationship inevitably never quite goes back to the same that it was pre-investigation. Very often we see the head teacher delegated to the deputy, or they just do the investigation themselves, depending on capacity. So I think the seniority is key. Thank you. Someone's got to go. The building's being locked up. We're going to end up locked in as well, Penny. So we better wrap up. Please do come back to Debbie with any suggested topics. We're really keen to run this as a series and open it up to pretty much any schools in the diocese who wish to attend these sessions. Really thank you for your attendance and engagement and your thoughtful questions. We will follow up with those documents we mentioned, but if there's any further questions, queries, suggestions, please do send them through either directly to us or via Debbie. Thanks again for your time, and see you very soon.